What a big day in courts across the country, specifically a huge day for President Trump. I have a lot of really good news to tell you about today in all three courtrooms that we're going to cover here, all right? You had the New York trial. We got good news coming out of that. We had the Supreme Court ruling on presidential immunity. We have good news coming to that. And we have the Harvey Weinstein case, where his rape conviction in New York was overturned by the highest court in New York. This ruling, I believe, could actually help President Trump as well. And so that is where we will begin. We'll start with Harvey Weinstein. So what the Supreme Court, or the highest court, I should say, in New York said was that the judge in the Harvey Weinstein case allowed witnesses that had nothing to do with the case to testify. In fact, what they had to do with was, quote, prior bad acts, meaning they were trying to paint a picture of just how bad Harvey Weinstein was, but it didn't have anything to do with the crime at hand. Clearly, he's a dirtbag, slimeball. He'll be convicted when he gets his new trial again. I guarantee that. But you can't bring in these witnesses to paint a picture that have nothing to do with the crime. Well, this is exactly what they are doing in New York. This is Alvin Bragg's strategy. So let me read to you from the ruling here in New York. It reads, "It is an abuse of judicial discretion to permit untested allegations of nothing more than bad behavior that destroys a defendant's character but sheds no light on their credibility as related to the criminal charges lodged against them." Now, that, folks, is exactly what they're doing to President Trump in New York. Take the first witness, this David Pecker. This is all about bringing in someone to talk about what the jury might perceive as bad acts, paying off a porn star to not talk about an alleged affair, and letting the CEO of the National Enquirer tip you off to any bad stories. But again, none of this has anything to do with a records-keeping case about legal expenses or campaign expense. So I think if I was the Trump team, I would march this ruling from New York's highest court into the judge in New York and say we shouldn't be allowing any of these witnesses. And I'm not sure that'll happen, but this was a legal analyst explaining what the ruling in New York for Weinstein meant.
The primary reason that this case has been overturned has to do with the judge allowing other women who were not part of the charges in this case, that they were allowed to testify to what we lawyers call prior bad acts. That is, acts they said were sexual assault done by Harvey Weinstein. What the highest court of New York says is that that evidence was so unduly prejudicial that its admission changed the course of the trial.
So, folks, unduly prejudicial. This is exactly what's happening in New York. The Harvey Weinstein case flies in the face of what the judge in the New York case is allowing. Now, that brings us to the case today, where David Pecker was on the stand and he's being cross-examined, and all of a sudden he can't remember dates from 2 months ago. Made him look really bad where he could remember somehow dates from years ago, which clearly shows he was coached on one thing, but not the other. He called President Trump a mentor and a friend. Interesting, to say the least. And then, maybe some of the most damning testimony was that David Pecker said he did the exact same thing that he was doing for President Trump, tipping him off about negative stories, to other high-profile individuals, including Arnold Schwarzenegger. Arnold Schwarzenegger wasn't running for president. He couldn't be running for president. All this weighed heavily in the favor of President Trump, that this whole thing is a sham. And in fact, President Trump was so even maybe astonished by how far it went in his favor today. This is how he put it when he came out of court this afternoon.
Today was breathtaking. This room, you saw what went on. It was breathtaking. And amazing testimony. This is a trial that should have never happened. This is a case that should have never been filed. And it was really an incredible day. Open your eyes. And we can't can't let this continue to happen to our country.
You know, it's interesting because I was watching Jonathan Turley, the constitutional attorney who often appears on Fox News. And he made the point that this case in New York is the exact reason why the Supreme Court is hearing this issue of presidential immunity. So your political foes can't go after you. This is Jonathan Turley.
The interesting thing about today's Supreme Court decision and the Manhattan case is that Alvin Bragg is probably the best lawyer Donald Trump has right now. He's making the case to the Supreme Court that there needs to be an immunity protection because he's the problem. This is exactly what the court was worried about. You've got these Democratic district attorneys clearly politicizing the criminal justice system. The Manhattan case is legally absurd.
All right, one of my takeaways from the Supreme Court case, which I thought was very good today as far as President Trump's prospects of what may come out of this from these Supreme Court justices. One of my takes is that the Supreme Court is fed up with the nonsense. They're fed up with the political persecution. Certainly, 6 of the justices are, and you might have more. This is President Trump's attorney in his opening arguments. I'm going to play the entire clip for you because it sums up the whole case from President Trump's perspective.
Without presidential immunity from criminal prosecution, there can be no presidency as we know it. For 234 years of American history, no president was ever prosecuted for his official acts. The framers of our Constitution viewed an energetic executive as essential to securing liberty. If a president can be charged, put on trial, and imprisoned for his most controversial decisions as soon as he leaves office, that looming threat will distort the president's decision-making precisely when bold and fearless action is most needed. Every current president will face de facto blackmail and extortion by his political rivals while he is still in office. The implications of the court's decision here extend far beyond the facts of this case. Could President George W. Bush have been sent to prison for obstructing an official proceeding or allegedly lying to Congress to induce war in Iraq? Could President Obama be charged with murder for killing U.S. citizens abroad by drone strike? Could President Biden someday be charged with unlawfully inducing immigrants to enter the country illegally for his border policies? The answer to all these questions is no. Prosecuting the president for his official acts is an innovation with no foothold in history or tradition and incompatible with our constitutional structure. The original meaning of the executive vesting clause, the framers' understanding and intent, an unbroken historical tradition spanning 200 years, and policy considerations rooted in the separation of powers all counsel against it.
Listen, when you're president of the United States, when you're any leader, a CEO of a company, but especially president of the United States, how are you supposed to take bold and fearless action if you think your political enemies are going to charge you criminally in a court afterwards? You can't. This would literally shut down the government. So what did some of the liberal justices do? They focused on wild official acts, made up speculation of what could happen. Now remember, we've had 47 presidents, and the system has worked very well, including through the Trump years. So this is not something that happens all the time. But listen to Elena Kagan talking about, what about a coup?
And he told the generals, I don't feel like leaving office. I want to stage a coup. Is that immune?
If it's an official act, there needs to be impeachment and conviction beforehand because the framers viewed that kind of
If
very
it's an
low
official
risk.
act, is it an official act?
If it's an official act, it's impeachment.
Is it an official act?
On the way you've described that hypothetical, it could well be. I just don't know. You'd have to, again, it's a fact-specific, context-specific determination.
That answer sounds to me as though it's like, yeah, under my test, it's an official act, but that sure sounds bad, doesn't it?
Well, it certainly sounds very bad, and that's why the framers have a whole series of structural checks that have successfully, for the last 234 years, prevented that very kind of extreme hypothetical. 224
years. It has worked. This is one of the arguments. But again, a coup. I mean, all of these things. We'll impeach the president then. If we have a coup, by the way, we got bigger problems than whether we're going to criminally charge the president.